both a registered voter and a property owner in the proposed territory. From what I can see, and I'm no expert, we have 96 petitioners who are both a registered voter of the district and also property owners of the district. We also have 8 petition signers who are registered voters of the district, proposed district, and who are spouses of property owners, and so they're not listed on the property, but they are registered at that property. Are they co-owners under state law because we're a community property state? I'm going to defer to legal counsel on that. The other petition signers that we have, I believe that there are 13 that are neither registered voters or property owners. And then there are 10 that are in this category of what I can consider questionable. They're registered voters, not in the proposed territory, but they own property in the proposed territory. And again, I'm not legal counsel, I'm not legal expert, but from the way the code reads, if you're strictly reading it straight, it says before a district located wholly in one county may be created, the county judge of that county must receive a petition signed by at least 100 qualified voters who own taxable real property in the proposed district. That's my report.
Questions of
Going back to the 10 questions, what you said here.
They are registered voters of the county, and they own property in the proposed district.
How are they different than the 96 that are registered
So
voters?
those 96 are registered in the territory, the proposed territory, and own property in the proposed territory.
And the 10
Those 10, they're registered voters, not in the proposed territory, but they own property in the proposed territory.
The difference is the registered voter, whether they're in the territory or not. 10 are not,
In the proposed territory.
which was the code, but it says
It does not specify.
qualified.
And a qualified voter, do you have any opinion on what a qualified voter is? And that is a registered voter.
a registered voter.
A registered voter,
It doesn't say anything else.
not in this particular case.
And of those 10, were they county residents?
Yes, they're county residents.
Not in the proposed district. For their physical.
They own property in the district.
In the
But they don't reside in the district.
They're not registered to vote.
In the district.
The registered address is outside of that.
They're registered,
Outside.
not necessarily in the district.
The 8 that have the spouses, name that's in the proposed district. They're not registered.
That's
They are registered voters. They are registered voters.
They are registered voters.
Not in the district.
Okay, so there's 4 different categories. And 96 of them were registered in the territory, property owners in the territory. 8 were registered voters, their spouses were the property owners at the same address that they were registered to vote at. Then you had the 10 that were questionable as they're registered voters, not in the district, but own property. And then you had like 13 that were neither registered voters.
So would that 8 qualify? Because their spouse is under their name or not?
To meet your burden of proof, I would rely more on the 10 who are qualified voters who own their property in the district. We're guessing on the spouse, I'm assuming. The status of the spouse is a little more questionable.
Even though it's property.
The other spouse could have inherited that property. That's separate. say where, they are, you confirm that. And there's no end. The who is the adjoiner. Who owns real taxable property in the proposed district? You've confirmed that those 10 own real property in the proposed district. And they are qualified voters. I don't know that they're questionable, my vote, based on that, based on, in my opinion, I would not, I have no party that before, I feel much more.
And I
I'm
think
not worried with that.
the 10 in question, I think they're all Uvalde residents as well. Seems like even municipal residents or is there a mixed bag?
Yes. So far, if I remember correctly,
I
yes.
know a couple of them off the top of my head, different ones.
The thing about this, one, I think the law is written that way to serve, hey, you can own properties, now but you also own property in the district, it's going to be served, that means they have to say, and what happens to their tax, their property is going to potentially be taxed and receive services as well that are proposed by this CSD. So it makes sense to me.
So they can be a signatory, but they wouldn't be a vote on the matter, since they didn't
Since
reside.
they're not registered, which that doesn't necessarily make sense, but obviously it's a joint petition. I think it's not clear if they were intended for the registered voter in that precinct, or in that proposed district, only to people, if they sign a petition, that would say so.
And it really serves, the previous ESD2 had a very similar situation where many of their signatures were asked to use property who were registered voters wherever they were from.
Yeah, I don't think that. So I think you're better off buying the 10 and to get above the 100.
That's the threshold one.
Yes, sir.
Any other questions for Melissa? Thank you, Melissa.
No.
Okay, you've heard the report from the elections administrator and also opinion from the attorney. And you have before you the issue.
Question for written law excluded. Is there a way of excluding from this?
Again, the statute doesn't say to once you get which places. The contents of the petition will be determined by the court. So I'll go back to 775.016, which says the Commissioner Court shall consider the petition each issue relating to the creation of the district. One of the issues is the proposed district area. Right? Talking about voters and property owners, that's one of that's several of the factors that y'all have to determine. Right? They proposed the entire district, the proposed area. You know, had a hearing where people have had the opportunity to speak. The third section says that you have exclusive jurisdiction to determine each issue relating to the creation of the district. What areas to be in for these issues as well.
Now, here's one question.
Put that out there for consideration.
Here's one question to me. So, since the numbers seem narrow, it appears to continue to just make the threshold here slightly over. If you excluded those wells, then that would also verify exclude the ones who signed from that part of the district.
Very good question, possibly so. But again, the statute is not, because you don't have a lot of facts when it comes to those type of questions. We have the exclusive jurisdiction to determine each issue. Doesn't tell you what you can exclude, you have to go up petition. It's pretty broad. So I think that's going to be a policy position for the party. I'm sorry, I don't have a better answer.
So that essentially extends the same issue extends to the tiers, sections of each thing.
Where any exclusion from what the petition So that's antithetical to the idea of excluding the territory on the basis of public hearing, which you've heard of other testimony. But that's just one way. We don't see that two different that's it's arguably the question.
So my other question, I think I don't know if the third or have we met, what was it, 9 stipulations or 7 stipulations?
I think it's seven enumerated there, but you also got to throw in the threshold which y'all already heard. We've met that threshold. That's your own determination of peers, as to what you heard, what you did. The peers based on. And of course, the others is the 7, and section 775.013, which is the contents. I think it has a statement that if it's created to operate under the Constitution, the name of the district, the boundaries, services that they propose, that implies that it does not overlap with another district, and naming address and petitions on there, and the name of each municipality, each consent must be retained, which I think that's in there too. Is that now? Yeah, consent. Now, after, close to the consent, boundary, then operating district.
And then the last one, I guess, was I'm assuming we met our finding requirements as far as the public services and all those things.
Regular wants to go the first day after they're happy. That's the way things operate right now. So sometimes that when we exclude them, there might be some signatures out there in that area. They can be excluded.
But is that a big substitute to us accepting the petition? Accept the petition, and we, as a court, can modify it to exclude.
It's vague enough, but I think the concern is that you're changing the nature of what was presented to the vote.
I agree.
I mean, I've gone through the list, but kind of work based on address, rural address, in that area. And I think the concern judge from that area is that it's kind of rush. You really didn't have a say so or not included or updated as to what was going to happen if ESD was created. So there's some concern there that if this district is created, if the voters approve it, they won't have a say so or a voice at the table. But that's what that area is.
Ultimately, what you have to decide today is to feel comfortable with those requirements. 9 things about it. And then your approval is based on feasibility and look at both public safety, welfare, health, and needs and personal design. Like a few comments, so in my precinct, I think I'm a little bit unique. I've visited around. I have ESD 2 in my precinct. Talk to those people, they're very much in favor of ESD. They're fine. ESD 3, I think ESD 1 is in my precinct. You talk to people, talk to them, they're very much in favor. They one comment goes, we really get our they cover multiple counties, they have their, so it comes back down the side now, and I've had overwhelming support 50/50. Yesterday, fire chief said it didn't make any difference because they were going to go with ESD2 and get annexed. So basically, that was a good point. I don't know, Bill, the agenda, I don't know if that's for us to address. And a few people from Uvalde admitted they think of it. And I feel like those are the people that are talking to me. I hear your concerns, Commissioner. I heard them yesterday, and I understand that, and I respect that. But as far as the people in my precinct, they want, it does need to qualify, it's new one. As long as we feel like it's right, then I'm referring to you, council. I don't have a vote, it's up to y'all to determine. I'm just excited about it, but I mean, we meet the criteria.
And we have the issue of the church, correct? Is that another?
That would be enough.
We need to clean up that area too.
Obviously, they're asked to appear in site radar rights, so that's.
But how do you say? Commissioner?
I mean, obviously I'm biased, so that's why
I asked you because that's your reason.
right. So I would say in my precinct, there's still confusion. There's many in favor. You know, I personally believe clearly, and I think most do, that the school district election clouded what the real pulse was in my precinct when they voted here with this last go around. Because many people thought they were voting on the school issue when they voted on the ESD, and didn't realize until they would come out. Many of us were there on election day, working our own campaigns. People would come out and say, well, I voted against the school line, and I said, oh, you remember to go all the way to the school? I said, no, it was on the ballot. I said, no, that's not what was on the ballot. So I'm not going to tell you that it's 100% in my precinct in favor, but I will say that I think the majority will go with it. If it was up, and most of my voters will not have any skin in the game this time, because the vast majority of my precinct voters are inside city limits. So obviously, I've said before, I'll say it again, I have stood in favor of it the last time, I remain in favor of it, but I'm not going to suggest to you that I know for a fact the pulse of what housing will be voted this time. In my case, they're not going to be participating in this.
My constituents are going to say they are, except the ones in the contract.
So if we do let the voters decide, I guess there'll be a board created, and the voters approve it, there'll be a board created, if the voters approve this measure, remember, if the board will be created, ESD, board, and hopefully we'll have equal representation on that board.
This board appoints that.
So logically, one would theorize that each of those four agencies would have representation. The question is, who would be that fit vote? That would be up to us if the voters cast.
I just said the board has to go to the point where the board can cover. We will have to go. To carve it out, like you're saying right now.
I may be ranking, but
I did it. Other questions, comments? Motion? We've already, this is not a public hearing, nobody, it's already been addressed, we're beyond the public hearing part of it, we asked for comments, so we're not accepting any more comments.
so I would say that based on what you presented to us, that we have met the burden. I think our only obligation is to do the burden, not whether we're for or against this plan. Do I wish that it was a plan that was presented the very first time? Absolutely. Is this muddier and more confusing to the voter? Absolutely. But I think the burden for us is merely, do they meet the threshold of the voter and property owner? If that's been satisfied, then I think we'll move forward. Very much.
Motion, second by Commissioner Copeland. Discussion on the motion.